this was something that was so obvious, stated, the plaintiff's out because of that. Now, I don't know what the facts were. The facts aren't contained in the appellate division decision. I haven't read Weisberg's decision in the Court of Claims, and I don't know if he has the facts in there. I would anticipate that there'd be at some point more discussion by the Court of Appeals about why 241.6 requires an implementing code provision. But if you're a plaintiff and you're pleading 241.6 in your bill of particulars, you better have an industrial code section pled, or you may very well be out of court. The reason I don't think it's a good decision is, number one, it doesn't explain why it's doing it. And number two, if you read 241.6, it doesn't say that the Commissioner of Labor must or shall make any rules. It says the Commissioner of Labor may make rules. Well, what's the point of the statute if it is? I mean, why is it there? Just to give him the rule-making authority? I think not. I think it's there to ensure that safe place to work is given. 241A covers elevators, shaftways, hatchways, and stairwells. It's another great section for plaintiffs because someone walks onto the shaftway and the plywood collapses, and you can go to the bank. Right? It's the same type of proof. I alluded before to construction managers. You're seeing more and more, certainly in the metropolitan area, construction management contracts rather than general contractors. And the labor law sections, as you know, refer to owners and general contractors. If you look at these contracts, however, with construction managers, they're usually given such broad supervisory powers, or they're designated as the owner's representative or agent on the job, and they're given authority to do really, in effect, what a GC would be doing, that you're not going to have, as a plaintiff, much problem in holding them in. And as a defendant, in most of these cases, I think you're going to be wasting your time saying, gee, the labor law doesn't apply because they're a construction manager. Basically, if it walks like a duck and quacks like a duck, it's a duck, right? And take a look at page 271. And I put in the decisions from Second Department, which held construction managers liable. And I don't think at this point in time there's really any dispute that with most of these contracts for construction management contracts, construction managers in as if it was a GC. As to the subs and primes, I spoke a little bit before about Russin and Larrabee and that line of cases. Again, to hold a sub or a prime statutorily liable, you must show delegation of the authority to supervise and control duties giving rise to accident. And if you're a creative plaintiff's lawyer, you can use that theory to hold possibly others in. 272 of the outline, the Newman case is cited where a professional engineer was held statutorily liable because he was given broad supervisory powers so as to make the engineer an agent for purposes of the labor law. And I've had cases similar to this holding in professional engineers where the evidence adduced, the discovery, was strong enough so that these cases were settled. So it's very important to be cognizant of those theories. Now, post-accident assistance. Obviously, whether you represent a defendant or a plaintiff, you must do a thorough investigation. Tom, at pages 42 and 43 of the course book, has an excellent checklist that you could go through, and it's really a good one. I've included some items which you should look for at page 273. I want to just I don't want to go over everything in the book. You're all capable of reading it. I want to discuss some of the highlights. OSHA, in every death case, and in a lot of the serious injuries, OSHA's going to go in. And whether you're a plaintiff, you got to go in and get that. It takes months sometimes to get it. And the way you get the OSHA reports is simple. You find out the area office involved, and you write to them, and you're entitled to it under the Freedom of Information Act. But you have to stay on top of OSHA. And what I mean by that is you write them every 2 weeks, and then you start calling them and driving them crazy so they don't forget about it. If you're a defendant, if you get involved in the case, hopefully before you get the complaint, you can start getting the OSHA reports too. I know that when I have these cases and they're put into suit, if a defendant's lawyer, and you get the same people in these cases, we all work together and know each other. If a defendant's lawyer calls me and says, gee, you got the OSHA? I say, yeah, I'll send it to you. So, no problem with that. You must get OSHA because your whole investigation is done for you. And you certainly should not take depositions in a case as a plaintiff without your OSHA investigation, if there was one. You're making a grave mistake. When you get these OSHA reports, the names are all blackened out. But I'll tell you this, if you do a thorough investigation, once you read it, you know who all the people are. You know who they had to go to speak to get the information they got. And OSHA regulations, by the way, are admissible at trial as some evidence of negligence. And it's getting harder and harder, but you can still do it. You can get these OSHA inspectors into court. Used to be a lot easier than it is now. You have to write to Washington now, isn't that it? You write to the Department of Labor and get permission and tell them why you need them. And you have to do it way in advance. But if you really have a case and it's a major case and you feel it's important to bring in an OSHA inspector, you can do it. They'll usually bring a Department of Labor attorney who will stand up there with them at the witness stand and object to any questions about opinions. They only want the factual. They'll only allow that. But at least you can get that in, and then you can have your expert have some basis to give his testimony. And if you have a 7-figure case or greater, you certainly want to do that. Workers' compensation file is very important, and I'll tell you one reason it's important is if the state fund is involved as an insurance carrier under the 1B for the employer, and it's a serious accident, certainly a death or a quad or paraplegic case, the state fund investigation, and they do a pretty decent investigation, becomes part of the comp file. So when you get your authorization from your plaintiff for the comp file and you go down to compensation to pick up your copy, you get the whole state fund investigation. And you should get that file too before you do depositions. It was mentioned before that you should get prior comp, and obviously prior comp claims, records. If you're a defendant, and if you're a plaintiff, you got to get these things too, because some of these workers have a long history of comp claims, and anytime anyone walks into my office with a disc injury on a construction job, I want to see his prior comp claims. Right? Because often there's a long history of back problems, and some of these people aren't as truthful as we might want them to be. And if you're a plaintiff's attorney, you want to find out about it before you embarrass yourself by bringing a lawsuit for someone who has a pre-existing condition and happened to fall and say, okay, you know, I hit it, right? So you want to know that, because you don't, as a plaintiff, you don't want to be bringing a case like that, and you don't want to be involved with it. So get the prior comp. Union records and contracts, as were mentioned, are essential. You want to give them to your economist. They must become part of your economist's testimony. The lost benefits, lost pension, lost medical, whatever, must be evaluated by the economist. As to witness statements, the trend, I think now, and Tom will correct me if I'm wrong, but the trend seems to be that there's more cases coming out now that give you summary judgment in a 240 case, even if the accident is unwitnessed. It used to be really that you couldn't get it. Fair enough?